Well, good afternoon. This is Steven Leskin, and welcome to tonight's Thursday night edition of Divorce Deep Dive. Tonight's topic is everything about judgments and enforcing them, not everything, enforcing them, modifying them, and appealing them. As usual, we're in about 45 minutes, and we'll get into it. I'll do a little introduction into the deep dive. We'll talk about me for a little bit, and then we'll talk about where we're at with judgments. This webinar covers a very specific point in time after the judgment. So after we have a divorce decree, what happens? And so this seminar is going to talk about what happens post-divorce trial. And so, like I said, we'll talk about appeal of judgments, when it makes sense to appeal, when it doesn't. We'll talk about enforcement of judgments, which is usually the big issue, and then modifications of judgments which come about as a result of a change in circumstance. So this is my deep dive series, and what I do is I take a topic and just do a really deep dive on it. And that's, sometimes you get into the weeds. I don't know if seaweeds, you get into the seaweeds, which would be the appropriate metaphor, and you find yourself running into sharks and all kinds of stuff. So that's why I use the shark metaphor. It's not the best, but it's what I got. And just some things to keep in mind. I don't take questions during this seminar. There's about 7, 8 people signed up tonight. If you want to call me tomorrow and have a question, or if you want to email me, my contact information is at the end. I'm happy to discuss your issue with you. I've just found that questions in the middle of my webinars tend to be disruptive. I lose my train of thought, but I am happy to discuss questions with people. So just give me a call. Say you watch the webinar, and I'll genuinely be happy to hear from you. All of these webinars get posted on my website, leskinlaw.com. They're also on YouTube. They are a great resource on any area of divorce law and family law. There's about 30 just of these webinars now posted online. They're under the resource tab on the website, and then webinars, and that will get you right to them. And if you have a question, that would be a good place to start. I don't use this as an infomercial. This is really not about me. I don't refer to my practice. I'm not really trying to sell anybody anything on these webinars. It really is just a focused look on the topic. I know a lot of times, like I'll go to a webinar, by a private person, and it's half a sales pitch. This is strictly, information that I hope that people will find useful. A little bit about me. I can go in depth if you want, but I don't think anybody's that interested. Well, yeah, no, nobody's that interested. I was admitted to practice law in Oregon in September 1992. I've been practicing family law since 2001. I'm the founder of One Day Divorce Mediation. I do litigation and mediation work. There's my phone number and contact if you haven't found it. And I do a lot of other stuff. I'm on the board of the Oregon Mediation Association. I volunteer around town quite a bit on different legal topics. You can find me at St. Andrews doing volunteer work there, or the Clackamas Circuit Court, where I do volunteer mediation. All right, so let's dive into it. So the question is, where are we at? We are at the point in time where you have a judgment, you have a divorce decree, and you either are going to want to appeal it because you didn't get a favorable ruling from a judge, modify it because circumstances have changed, or enforce it because your partner isn't living up to the terms. So let's start with just some basics. There are three types of judgment. There's the general judgment, which resolves all of the issues in a case. In a way, on the way to getting that judgment, there may be, particularly in family law cases, there may be a limited judgment, and a limited judgment awards temporary support or temporary child support or temporary custody or exclusive use of the house in a divorce case or a custody case. Um, so general judgment resolves everything. Limited judgment is between the time that the divorce is filed and the judgment. Anything post divorce decree, anything post the general judgment is found in a supplemental judgment. So, for example, you may want to modify spousal support. Uh, you may be a husband who's paying spousal support, and your ex has gotten married. Well, that's change of circumstance, and you might want to come back and modify your spousal support award so you don't have to pay, or you don't have to pay as much. Uh, and the result of that hearing will be a supplemental judgment. So maybe you get all of your spousal support terminated. There'll be a supplemental judgment which terminates spousal support. So that's a modification. That would be a modification of the general judgment, which results in a supplemental judgment. For our purposes, just for our purposes, this is not true in general, but for what we're talking about here in family law, there are two types of judgments. There's a judgment of dissolution, which ends a marriage and divides the property and takes care of the kids and awards spousal support. And then there's a general judgment of custody, where two people have a kid, there's no marriage, and then the only three issues in the general judgment of custody will be who's going to get custody, how parenting time is going to be allocated, and child support. There are lots of different other types of judgments. Like, for example, if you brought a personal injury case, that would just be called a general judgment, but it would be a personal injury case for, um, it'd be a personal injury general judgment. It would just still be called general judgment, but it would cover different things. So let's get into appeals. Uh, I don't personally do a lot of appellate work. I've brought very, very few cases to the court, to the Oregon Court of Appeals. And just the Supreme Court, the federal Supreme Court is in the news a lot. So let me just make sure we're all on the same page. We're only talking, family law is governed generally by state law. Uh, if you bring a divorce or you have relationships with your issues with relationships with your spouse or your kids, those are all going to be generally state law issues. There's some exceptions to that. I'm not going to get into it. But whenever we're talking tonight, we're always talking about the Oregon courts. So Oregon Court of Appeals, Oregon Supreme Court. The structure of the Oregon courts is there's a circuit court and there's administrative courts. The circuit court is within the judicial branch of the government. Administrative courts are in the executive branch. And an executive court, I misspoke, an administrative court will handle such things as child support, workers' comp, or employment benefits. If you want to appeal a administrative court decision, it will generally go to the circuit court, and then you're back in the court side of things in the judiciary. Um, if you want to appeal your circuit court case, you appeal it to the Oregon Court of Appeals. And if you don't like the decision in the Court of Appeals, you go to the Supreme Court. There are not that many family law cases that are decided in the Court of Appeals. It seems like that number is diminished. There's a reason for that. I'll touch on that in just a second. But there's not a lot of family law cases that are making their way into judicial appellate decisions. And there's far less Supreme Court decisions dealing with family law cases. I think last year there may have been one, just off the top of my head, I can think of one, and it was on a really, really, really narrow issue of law, and it was very technical, and I don't know why it was so narrow and had such narrow appeal. I'm really not quite sure why I made it up to the Supreme Court in any event. Um, Part of the reason why there's less decisions at the Court of Appeals level is because last year the court decided that it could write non-precedential decisions, which means that the court will write a decision, but it doesn't have precedential value, meaning that the courts cannot, like lawyers can't cite to it as authority on how a circuit court case should be decided. And there's actually a fair amount of um, non-precedential opinions, and it would be helpful if they went into if they were precedential. I frankly don't understand why the court does this, um, and I just if you're going to write a decision, I wish they just write a decision so that we could all benefit from it. The precedential decisions are instructive. You can look one up and see that, the court used this case or that case or this statute to decide the case in front of it. And so that gives you some insight in how the court will think about it, or maybe you'll find some law that you didn't know about. But generally, it's diminished the amount of uh, cases out there that lawyers can rely on in arguing their cases. So that was a little detour. Um, if you wanted to, uh, going to court, you've been to court, you know that it is a really labor intensive endeavor. Uh, Appeal court cases are also extraordinarily labor intensive. When you go to circuit court and you have your day in court, the court's creating a record, and that record is everything that's admitted into the record, the documents, the testimony. Those are part of the record. And any appellate level decision relies on that record. So um, it getting the record together, writing appeals based on that record and the law, very, very labor intensive. And um, you really kind of have to know what you're doing because you may be setting law. Um, the question is then what can an appeals court do with a decision that is appealed, with a judge decision that's appealed? An appeals court can only do a couple of things. It can affirm the decision. It could say that we've reviewed the case and the law and the facts, and we've decided that it was correctly decided. And generally, that's what happens. It can send the court case back to the trial judge for further development of the facts. The appeals court could say, well, you didn't get it quite right, and we need to know X, Y, and Z, and it will send the court back to take testimony and make a decision based in light of the court's ruling. And then in rare cases, the court could reverse a decision and just, that's not so rare. What I was going to say next is rare. The court could say, we're reversing your decision and we're reversing this back to you for remand to retry again, or to make a new decision based on the record in the case. And then finally, the court could just make a decision. The court could say this was wrongly decided, but we have enough evidence in the record to make a decision on the case. And that happens, but rarely. Part of the reason it's so hard to get a case reversed is because the standards for doing so are very, very high. The court can review a case for errors of law. And so, for example, if it's a custody case and the court just fails to consider what's in the best interest of the child, that would be a reverse case because the court applied the wrong standard. Generally, um, uh, the court's not going to make a legal error, but if the trial court applies or misapplies a legal standard, then the case will come back to the circuit court for a decision. There's also something called an abuse of discretion. So uh, the legislature uses a lot of like buzzwords and like just and equitable in all the circumstances or best interests of the child. So those terms are found in law and they don't really describe anything. I mean, just and equitable in all the circumstances. What does that mean? So whenever a statute sets down that type of standard, that means the judge has discretion in how to make a decision. But that discretion is not unfettered. The Court of Appeals will look to the record and say, was there any evidence to support the judge's reasoning? And if there's any evidence, um, that can be taken from the facts or inferred from the facts, then it's not an abuse of discretion. So that is a really, really tough decision, tough standard uh, um, to get a circuit court case reversed. Let's get into enforcing judgments. So, what to do when your ex does not comply with the judgment of the court? That's what this section is all about. So, for example, supposing there's either divorce, a dissolution judgment or judgment of custody, and there's a parenting plan, and dad just keeps refusing to bring the child home to mom, or doesn't during mom's parenting time, or does so consistently late, or just is not. Well, let's just stick with parenting time, or is disparaging mom and there's a non-disparagement clause in the parenting time. What can mom do? So, Oregon statute, Oregon Revised Statute, that's the ORS at 107.434, um, provides an expedited parenting spoke an expedited parent plan enforcement mechanism, and so it's an attorney can use this section, but it's really intended, even the way the statute is written, it's intended for non-attorneys. The statute talks about the courts providing forms for people. So if you have a parenting time issue and you want a quick resolution of it without hiring an attorney, you can call up the courthouse or go online and find the forms and file and just go ahead and file the forms. Um, you have to have proof of the violation of the parenting plan, obviously. So you need to be able to like document, like dad is bringing the kids home late. So how can you document that? Well, you take, some videos of the kids coming home, and they're time stamped, right? So things like that, something that you can bring to court to demonstrate that, the kids are supposed to be home at 6, and every night they're or every time dad's parenting time, they're not coming home to 8 or 9 or whatever. Uh, document that a couple times. Once, you're not going to do it for once, but if it's a pattern, you can certainly uh, bring the case to the court. The court has the authority under 107.434 to modify the parenting plan. The court can impose additional terms. Those terms may include a bond or security. I've never seen that happen, but a judge could say, if you don't comply with the terms, you're going to lose your bond. The court can give the aggrieved parent, in this case the mom, additional parenting time, um, uh, especially where parenting time has been withheld. The court can also hold the offending parent in contempt, and that might mean jail, it might mean fines. Um, it's not clear what from the statute how the court would go about holding an offending parent in contempt, but the court has that power in any event whenever a judge's order is ignored or not complied with fully. You can always hold the court can always hold um, somebody in contempt, um, even though it's rare, but it definitely happens. I've been in court where, on other cases where somebody will come into court drunk or disrespecting the judge, and the judge will say, why don't you spend a couple of days in jail to think about your conduct? So that's a form of contempt, and it's not appealable. It's the judge's power to do. The judge has the right to maintain order in the courtroom, and I've seen that happen plenty of times, where judges just you're out of line here. You can spend a couple of days thinking about it. If an attorney does bring an enforcement action under 107.434, the attorney could get their attorney fees paid by the offending parent. The court could also schedule a time to modify custody. So suppose the all right, I'm gonna go back. I'm gonna go back. Let me go back. I'm back. Um, uh, Supposing it's the mom who has custody and is getting the kids, the dad late consistently. Dad could ask the court during an enforcement uh, to to schedule a time to challenge custody, to modify custody, and claim that that's it's now in the best interest of the kids that dad should have custody. In that case, I've done hearings. I've done plenty of webinars on custody. If you wanted to dive deeper into that, but then the court would look to another statute to determine whether or not it's appropriate to modify custody. The court can also compel attendance at a parenting class or at counseling. The judge does not have that authority in a dissolution or custody matter. Only when you go through this statute 107434 can a judge compel one of the parties to counseling. And finally, the judge can modify or terminate spouse support or child support. So if in this case, if dad continued to um, not pay, not get the kids home on time, and he was paying spouse support, the judge could say, well, I'm going to tack on another $50 a month or another $100 a month to your spouse support award, and then um, that new requirement would go in a supplemental judgment. All right. So supposing the issue is not just parenting time, supposing there's other issues that one of the parties, one of the ex-spouses is not complying within the judgment, how do you go about enforcing the judgment then? There is only one mechanism, and it's kind of a sledgehammer, and that is contempt of court. And a party in the divorce context, some examples, this is not exhaustive by any means, but some of the examples that somebody could be held in contempt of court for: non-payment of spousal support, non-payment of child support, non-payment of debts assigned to the party um, to pay, not surrendering personal property. The judgment says father gets says mom, I misspoke. Wife gets the Mercedes and the husband refuses to surrender it. Mom can go to court to get a contempt, file a contempt action against dad and get the car that way. So not complying with transfer of personal property or going through the process of conveying real property or interfering with parenting time or custody. So those are some of the grounds that you go to court on contempt for. The reason contempt is such a big hammer is because there are huge financial penalties for somebody found in contempt of court. There may be, in certain types of contempt cases, there may be prison time. You can get an award of attorney fees against you, so you got fines, attorney fees. So contempt is really a cudgel. Uh, Sometimes the fines can be as high as $500 a day, but by statute, they can be as high as $500 a day for each missed day, for every day of noncompliance with the judgment. So contempt is really a hard measure. The thing about contempt is that it has to be proved by clear and convincing evidence. So if somebody, if you just come in and say, well, dad's not getting the kids back to me on time, that's not going to be clear and convincing evidence. You have to have some type of document, evidence, another witness, something to show that this happened to a near certainty, not just, well, dad's late all the time. It is a defense to contempt. Let me say it like this: impossibility is a defense to contempt. So, for example, husband's ordered to pay spousal support, and it contracts a debilitating illness, is unable to work, and therefore unable to pay spousal support, then impossibility is a defense to a contempt action. But it's I didn't feel like going to work. I changed jobs. I wouldn't have to pay. Those aren't impossibilities. Impossibilities is there is some objectively some objective basis that you are prohibited from meeting the needs under meeting the requirements of the judgment. There's another Oregon law also provides another enforcement mechanism, uh, and it's an order of assistance to obtain custody of a child. So um, when a person has been to court, when mom or dad's been to court, and there's an order saying dad's got custody of the child, um, under Oregon law, that's a custody order, right? Um, if the other parent or another person is interfering with that custody order, uh, the aggrieved person can go to court and get an order of assistance from a judge, uh, and that order of assistance will direct law enforcement to retrieve the child. So the requirements are um, the aggrieved parent must be entitled to physical custody under a valid court order, and the child is being held by another person in substantial violation of the custody order. So you might be thinking, well, why is that not kidnapping? In Oregon, by law, kidnapping does not apply to a relative. So a relative in Oregon cannot kidnap their son or their daughter. I frankly I don't know what happens like if you were to kidnap a child and take it to like the Middle East, right? And you hear that scenario playing out sometimes. There are ways to get the child back under what's called the Hague Convention, but that's still not kidnapping. That's involving authorities in another nation to help retrieve a child. Uh, that never comes up in my practice. It's not something I'm familiar with, but you know, I know that there are mechanisms for retrieving a child against a court order. This particular statute, the writ of assistance, does not apply to like parenting time or visitation. So, like the example we were talking about, where dad was consistently getting a child back to mom a couple hours late, you're not going to get a writ of assistance for something like that. This is where the child's not being returned home. I think that was it on enforcement. So we'll get into modifying judgments now. So let's take the situation that we uh, hinted at a little while ago, where dad's obligated to pay spousal support and mom remarries. Uh, in those kind of circumstances, the remarriage is considered a significant change of circumstance. And a party, the husband in this case, can go back to court and say, "Well, I got to pay spousal support. She's remarried. She's got more assets now. Her circumstances have changed. She no longer needs the support that the court ordered." Um, and so that is a modification of a judgment. In that case, there may be a termination of spousal support. So the termination is a form of modification. Uh, what can be modified? Uh, I want to start with what cannot be modified. Property divisions cannot be modified. And so you cannot go to, like, you cannot be awarded the house and then come back, and then the other party come back and say, well, I want to modify how the house is going to get um, sold or divided. You cannot do that. You can't modify like who's going to pay like the debt. Those are property divisions, and those cannot be modified. Um, short of that, anything else in a judgment can be modified. So spousal support can be modified, custody can be modified, parenting time can be modified. Um, Modificate, so you have to show that there's a significant change of circumstance, and any modification involving a child needs to be made in the best interest of the child. So um, uh, you can go to court and say, well, mom who got married a somebody who's on a sex offender register. The court's going to look at that and say, well, you have grounds to modify, and it would now be in the best interest that um, the child is never left unattended with the new husband, or that dad should have more parenting time, and there's other other modifications to adjust to the new reality. So Modifications generally have to have a showing that there's a significant change of circumstance that go to why the judge ordered what the judge issued. So, for example, you could not come back and say, um, uh, um, husband, wants to terminate spousal support uh, because wife moved into a blue house, right? It would have no bearing on the case. It has to be something that goes to um, the reason for the award. Modifications of parenting time do not need to show a um, significant change of circumstance. uh, you have to show that the change that you're proposing is in the best interest of the child. And so that may not necessarily be reflect a change. You may go to court and say, I want more parenting, more after school parenting time because the child is struggling and mom's not giving, child is struggling with schoolwork and mom's not letting me tutor the child. Court's going to probably say, okay, well, you don't need to show a change of circumstance, even though the struggling with schoolwork may be a change of circumstance. Uh, all you have to do is show that your proposed change is in the child's best interest. Um, and at some point, that's kind of a low bar because children age and they mature and circumstances change. And what was in the child's best interest when the child was 5 is going to be different from when the child is 12, right? And especially when the kids start hitting puberty. So uh, no change of circumstances necessary. Just it just continues on with what's in the child's best interest, and inevitably there'll be some change of circumstance in that. So that is appeals, modifications, and enforcement. Uh, as I was as I was waiting for this seminar, um, after I put this together, and as I was waiting tonight, I got a text from an attorney, an email from an attorney about um, collections and um, uh, well, it was about collections and how you collect on a judgment. That's not really the topic, but I will just cover that really briefly. Once a party has a judgment, so supposing a wife agrees to pay husband $50,000, and there's a judgment against a wife for $50,000. Husband then has the right to collect on that $50,000. Husband can, if there's no other criteria or conditions in the judgment, husband can submit a serve a writ of garnishment on a bank for $50,000 if wife on wife's bank. Husband can seize wife's assets and sell them and have the proceeds credited against the judgment. So those are also ways to enforce a judgment through collection processes that are that attach to or inherent in having a judgment against somebody. So I just wanted to throw that in as bonus. This doesn't cost any extra. There's not going to be a quiz on that. But it just occurred to me as I was waiting for tonight's seminar that there was one more topic that I could have discussed. So tonight we covered different types of judgments. We talked about the type general judgments and supplemental judgments. Uh, we talked about uh, appealing a judgment and how uh, difficult that is, and what standards that the appeals court judges use to make a decision to remand or affirm or um, um, reverse a circuit court decision. We talked about enforcing judgments and some of the tools that are available to enforce a judgment in family law court. And finally, we talked about how to modify a judgment. So I hope you found that helpful. If you have any questions, like I said at the start, I'm more than happy to talk with people. If you want to give me a call, my contact information is right here, and I'd be happy to hear from you. I generally hope you all found this helpful. I enjoy doing these. I'm happy to do these, and always will welcome the feedback. If you want to, it's cliche to say this, but I'll say this now. But if you want to give the meet, if you were on Meetup, you found me through Meetup, give me a good thumbs up. That would be appreciated. If you want to write a brief review on Google, that's always appreciated as well. So thank you for attending, and best of luck. Best wishes.